This podcast is published solely based off the interests of Jacko Law Group, PC, and in no way be construed as legal advice. The opinions shared reflect those of the authors and not necessarily the views of Jacko Law Group, PC. For more specific information or recent industry developments or situations, you should seek legal opinion or counsel. You are hereby notified that any review, dissemination, or copying of this message and its attachments, if any, is strictly prohibited. These materials may be considered attorney advertising in some jurisdictions.
Welcome to Jacko Law Group's Securities Regulatory Compliance Podcast. I'm Jeremiah Pagano, attorney and certified exit planning advisor at Jacko Law Group PC, JLG. We've created this podcast to break down complex securities law, regulatory compliance matters, and corporate law topics for business owners and professionals like you. Today, we'll be discussing the 3 best tax practices to employ when carrying through an M&A transaction. You may already know how to navigate the potential debt implications and tax liabilities for mergers and/or acquisitions, but these best practices will keep you on track. First off, it's recommended that you perform sell-side tax due diligence before the sales process begins, because an unexpected material tax issue could drive your buyer away. Plus, lacking a clear understanding of a company's tax position, areas of risk, or benefits can put sellers at disadvantage during the negotiation process. By carrying out sell-side tax due diligence off the bat, you can identify potential concerns and keep the seller in the clear. Next, we recommend evaluating any available alternatives to tax structuring. Sellers always desire a tax-efficient transition, one that maximizes after-tax proceeds. Identifying a preferred structure at the beginning of the sale allows sellers to plan a sale with a tax-efficient disposition. And by exploring more preferred alternatives, a more favorable purchase price can often be reached. Lastly, as a seller in an M&A transaction, be sure to negotiate the tax aspects of the purchase agreement. It's important for sellers to know the sections of a purchase agreement that will have an impact on the tax consequences created by the transaction. It also states pre- and post-closing tax matters, as well as the buyer's right to indemnification for tax liabilities of the purchase. By employing these 3 practices, especially sell-side tax due diligence, you can ensure 3 outcomes for your buyer: remediated exposure, an expedited deal process, and clearly defined tax attributes. Our team at JLG is available to help implement these tax practices and ensure an obstacle-free merger and/or acquisition. To find out more and to speak with our team, we invite you to contact us at 619-298-2880 or find us online at jackolg.com. Thanks for listening. We hope you have a great day.